I'm criminal defense attorney Ryan Pacyga, and today I'm going to talk about how a federal grand jury works. And this is different than how state grand jury works, which would be a different video. But for federal grand juries, what happens is a federal prosecutor will bring together a grand jury, and that means there's 16 to 23 people depending on the federal district. And they come together for usually a couple days a month. And that grand jury gets together and the federal prosecutor presents evidence to the grand jury and asks them to issue an indictment, which is a criminal charge. And the way that works is that the federal prosecutor will subpoena witnesses before the grand jury gets together and give them, those witnesses, advance notice that they're ordering them to come to court and testify before a grand jury under oath. Grand jury proceedings are a lot different than a regular court hearing or a regular court trial for a couple reasons. One, in a regular court trial, you have a judge and you have a defense lawyer and you have a jury usually of 12 people in a felony criminal case and a court reporter and so forth. A federal grand jury proceeding is considered secret. A judge is not allowed there. The defense lawyer is not allowed in the room. There's no right for the defense lawyer to cross-examine any people testifying before the grand jury and the like. So the prosecutor really gets to even put evidence before a grand jury that might not be admissible in a regular criminal trial. And that is because they're asking a grand jury simply to issue an indictment, which is kind of like probable cause that a crime may have occurred by the defendant, as opposed to later in a criminal trial, the burden of proof is beyond a reasonable doubt that they have to prove to a smaller jury of 12 people, which is different than the grand jury. So the prosecutor will issue, let's say they issue you a subpoena and they order you to come to be a witness at a grand jury proceeding. You might get there early and you can have a lawyer. If you receive a grand jury subpoena to be a witness, you can contact a lawyer and have them come with you. They just cannot go in the grand jury room. But the prosecutor will assemble these witnesses, and one by one they'll bring them before the grand jury and they'll testify before the grand jury, and the prosecutor can sort of spoon feed them questions and ask them to answer those under oath. And the grand jury can tell the prosecutor, look, we want more information. The grand jury can even ask questions of the witness, and eventually after the prosecutor has brought all of the witnesses forward, the grand jury will make a decision on whether they think there's enough information to issue an indictment. Their decision does not have to be unanimous. It's usually, depending on the jurisdiction, 2/3 to 3/4 of them out of that 16 to 23 people is enough to issue an indictment. If the grand jury issues an indictment, then that is a criminal charge, and then the prosecutor can go have the U.S. Marshals or FBI or whoever go arrest the defendant if the defendant hasn't already been arrested and bring them forward to court. If the grand jury rejects to issue an indictment, the prosecutor can keep going and ask the grand jury what more do they need in order to issue an indictment. And an old saying says that you can indict a ham sandwich. And while it's probably a little more difficult than that, the point is that because the rules of evidence generally don't apply, because there's no right to cross-examination, there's no right to point out any flaws in a witness's testimony or any bias or so forth. It's fairly controlled by the prosecutor, and if they want to get an indictment against someone, they usually don't have a whole lot of trouble getting that done. So that's essentially how a federal grand jury works. Again, if you are subpoenaed to be a witness, you want to talk to a lawyer, because anything you say to the case agents, which are like the FBI, DEA, or whoever's investigating the case, or the grand jury, could later be used against you. So you should contact a lawyer if you're subpoenaed to be a witness at a grand jury and get advice about, whether you should be reporting to that with or without a lawyer. And then, of course, if you are a witness there, you have a right to step out after each question and consult with your lawyer before you answer the question. Some jurisdictions also allow you to take notes of the questions. And while grand jury proceedings are secret, there's nothing that makes a witness have to hold their information secret to their lawyer or anybody else. The grand jury can't talk about it, but certainly a witness in a grand jury proceeding can generally share information after they've testified at a grand jury proceeding. If you have more questions, I'm criminal defense attorney Ryan Pacyga. You can find me at arrestedminnesota.com or at 612-339-5844.